Good afternoon, everyone. As Jill said, my name is Jennifer Monthie, and I work at Disability Rights New York. The second half of the presentation, I'm going to talk a little bit about Disability Rights New York. Some of you who participated in the training about a week ago may have heard some of the things, so I hope I won't have to repeat myself too much, and I'll keep you guys engaged. But I direct 3 of our programs at Disability Rights New York. The program for people with intellectual and developmental disability, which is called our PAD program, and the program for people with traumatic brain injury, which is called our PAT-B program, and the program for assistive technology, which is called our PAT program. And I'll describe a little bit more about Disability Rights New York, but generally we are a not-for-profit law office who operates in across New York State as the federal designee of the Protection, Advocacy, and Client Assistance Program. And we have offices right now in the Albany area, which is where I'm broadcasting from today, and in Brooklyn, New York, as well as in Rochester, New York. So I'll describe a little bit more about Disability Rights New York, and if you have any questions about our organization and what we do, I can address those towards the end of the presentation. So I thought I would start today and talk to you about entitlements and benefits, which is the third thing on this list of rights, responsibilities, entitlement, and opportunity for this presentation. So I wanted to start with today talking about one of the largest income maintenance programs, which the United States has several income maintenance programs, which is really referred to as social insurance programs. And they're designed to replace the lost income that an individual due to retirement, disability, or death. And the largest program, which is the first one on your list, is the Old Age Survivors and Disability Insurance Program, OASDI. To be eligible for this program, funds are taken from a worker's wage. And I'm assuming all of you are participating in this because it is a part of your employment. So as you participate today, a portion of your wage is being taken for this very program. The idea is that the program then takes the wages and then it becomes a part of this income maintenance insurance program later, whether you retire or due to disability or death. About 96% of jobs in the U.S. contribute to this fund, and 3 in 5 beneficiaries of the program age 65 or older rely on the OASDI for at least half of their income. So it is a substantial amount of beneficiaries that need this program in order to maintain their standard of living in retirement. The maximum monthly benefit for workers who are retired is $2,639 a month. Other programs that are on this list include unemployment insurance, workers' compensation, temporary disability insurance. All these programs are for employees that are unable to work due to a loss of employment. And what I'd like you to keep in mind, and the reason why I start with this is because I want you to think about that maximum amount that that I've listed here at the bottom of the slide when I talk about the other benefit program, which are more likely to be a program that individuals that you serve are, of course, a part of. So that program is the assistance programs that are out there, which are different than the insurance programs that I just talked about, in the sense that these are programs in order to try to provide benefit to people who are very close to the poverty line or very low income, so that they would, without these programs, be in poverty. So one of the programs that I want to talk to you about is the Supplemental Security Income Program, which is the first one. It's operated by the Social Security Administration, which many of you probably know about. But the program is to assist individuals who are unable to work or who work but earn money below the federal poverty level. And these programs are income contingent, meaning that only individuals who earn below a certain amount of money or have a limited amount of resources are eligible to receive these benefits. To delve into the SSI benefit, Supplemental Security Income Benefit, the program consists of 2 parts. There's a federal program part and a state supplemental program part. This is a fiscal benefit, but those eligible for SSI are also automatically eligible for Medicaid benefits. And the basic requirements are citizenship, with a limited exception of some refugees or immigrants being able to be part of it, income and resource levels, age, and disability. So for SSI, the countable income of the individual must be less than $5,808, and the assets must be lower than $2,000 for an individual. So these are individuals that have very, very little money. For those, in addition to having very, very little money, in order to qualify for SSI with a disability, the person must be unable to engage in any substantial gainful activity by reason of any medically determinable physical or mental impairment that can be expected to result in death, or which has or is likely to last more than a 12-month period of time. So let's unpackage that a little bit. Substantial and gainful activity is not just the ability to perform a job that you once had and you were very good at, but it's the ability to perform any type of activity that could result in meaningful gainful employment. And that's really examined for, that's the standard for anybody above the age of 18 seeking SSI benefits. And that needs to be re-examined on the eligibility of SSI each year that the person is assessed for SSI benefits. There are several programs that encourage individuals with SSI to seek work. For example, a certain amount of the person's income for a job will not be, quote, counted as income for their receiving of Social Security income. SSI. Currently, the first $85, which is a $20 initial exemption and then a $65 earned income exemption, will not be counted when you're determining SSI payments. After this number, SSI payments are reduced by $1 for every $2 the person earns. There are also special programs for individuals with disabilities that work so that they can continue to receive Medicaid benefits and other benefits while they work. It's really important when you're looking at an individual that gets SSI benefits that you note that a person who is either full-time or part-time employed will generally earn more money, even with the $1 to $2 exchange, than if the person did not work and only received SSI benefits. And I think that's a misconception amongst the population that we serve at Disability Rights New York. There's a perception that there's no way that a person could earn enough money to make it worthwhile given the amount of SSI money that they receive. And I'll tell you why in these next slides. And I hope people really understand how difficult it is to live at live with the only benefit you're receiving is SSI benefits. So the federal government sets the amount of the federal share for SSI, and this number used to be set by the federal poverty level, but now is set by a formula that includes a cost of living analysis. This should actually say 2016 instead of 2000. I'm sorry, it does say 2016. So as of 2016, there was no increase in the cost of living analysis, so there's no increase in SSI benefit payments. So the current maximum amount a single person can get per month in SSI benefits is $733. And for a couple, a married couple, where the spouse is also eligible for SSI, the maximum amount is $1,100 a month. I think, it's really, for me, startling when you compare this to the maximum amount that someone under the OASDI program could receive as a retiree, which is that number, again, on the first slide was $2,639. So, again, that's the maximum benefit, but setting the max benefit for SSI at $733 and the max benefit for the other insurance-based program would be over $2,600 tells you the difference in the amount of how an employee who pays into the system and is employed will receive its benefit level versus an individual that is non-employed and receives income solely by the SSI program. The last chart I want to talk to you about is the comparison to the federal poverty level. Currently, this is a 2016 number. This chart includes, in point 1, what the chart is, the first column, sorry, gives you the household size. So for 1, you see all the way on the left-hand side of your screen is for a single person. The poverty level is set at an annual salary of $11,880. So 100% of the poverty level would be $990 a month, whereas Social Security beneficiaries receive $733 a month. So individuals receiving Social Security are living below the poverty level. And so one of the things that I was asked to talk to you about, which I want to talk to you about before I get on to the responsibility of the employee, is the pushback that you might be receiving of an individual who has been living quite some time on Social Security benefits alone and is concerned or questions why they should seek employment or get into an employment program that requires them to work, maybe in a when they haven't had to work. And the bottom line is that those individuals just receiving Social Security benefits for the entirety of their life are going to be living below the poverty level. They are never going to accrue any retirement benefit to be able to be in the programs that a wage earner would be able to receive. And so their ability to move above the poverty level is going to not exist unless they get into the workforce. And so I think these are, people who are choosing not to want to explore employment options. I really think it's important that we use these numbers and use this information to make sure that they're making an informed choice and to place them in concrete values. So when doing a budget with $733, that's a very little amount of money on a weekly basis. Oftentimes these individuals are not just sacrificing the luxuries that you and I might say are luxuries, but they're sacrificing, basic needs and called food and clothing and shelter. And to be able to talk to people about the opportunity to work and why people work is because they want to improve their quality of living, and to understand that work equals an improved quality of living. So I'm going to switch over to the responsibilities of an employee. That was my pitch for why people should work and why people should work as much as possible, and it's something that we at Disability Rights New York really focus on with our clients. And when we can show them concrete reasons why they should work, often they will choose work because they understand the benefits that they can start to have with a salary versus with just SSI money. So the responsibility of an employee, I think, is really to understand what environment you live in when you are working in New York. New York is an employment at will state. This means that the employer may terminate an employee at any time for any reason, unless there's a law or an agreement that says otherwise. For example, this first one on the list, union contracts or collective bargaining agreements. Some of you may be a part of a union or a collective bargaining agreement. Oftentimes these say that the employee is protected from discharges without just cause, which is not true under an at-will. Even if it seems unfair, an at-will employee can terminate an employee even when it seems unfair to terminate them. There's also usually in collective bargainings or these union contracts, there's some type of grievance procedure that exists to protect the employee before they're terminated, and that they can follow that procedure. Other employees may offer. Other employers may offer individual contracts, which is interesting to, examine when you're assisting someone in getting a job. Is there a written contract which limits the employee's right to fire the employee? Some employers do have that. It's really the responsibility of the employee to read and understand those contracts. The other one is an employee handbook, which I think are often ignored by individuals, and I will say individuals with and without disabilities are ignored, but they're often required to sign them. And some of these handbooks do create a right So oftentimes we get contacted by people who have been terminated from their job, and we're asking, so where's your handbook? What is the things that your handbook says? And they said, well, I don't have a copy of it. So they can't even figure out if they have any rights under that handbook. So getting a copy of the handbook is really very important. Most relevant to this population that we're talking about today is the disability discrimination. So one of those exceptions, which is unless otherwise, agreed to or under law, is under federal and state and some local laws, an employer is prohibited from terminating a person because of their disability or terminating an employee in retaliation for opposing a practice that's forbidden under federal or New York state laws. And so that's what I want to talk to you guys a little bit so that I think generally some people that assist individuals with disabilities and get a job have a general understanding of some of these anti-discrimination laws, but I want to talk a little bit more specific today for a little bit. So before I get into these kind of rights, I want to introduce this concept to you as someone that might be helping people get jobs. And I think that we need to also understand employers a little bit and why employers are hiring or not hiring people with disabilities. And I do think it's important that an employee understand and learn about what employers are saying about hiring people with disabilities as well. So there have been several studies that have been conducted of employers over the last decade, and as it relates to people with disabilities and hiring people with disabilities. These studies point to the problem of employability for people. So the studies really started, and I have like 9 of them here, but there's several of them. They started under the premise of why are people with disabilities not being hired? And what the premise starts with, the people with disabilities are the least likely to benefit from a good hiring market and the most likely to be harmed by a slow hiring market, which means that they are the last hired and the first fired. So these studies are really trying to get at whether employer attitudes contribute to that, like why employers wait so long to hire people with disabilities and they're the first ones that are fired. Most of the studies that have come out since the mid-'80s or the late '80s have said that larger corporations, so the Fortune 500 companies, are more likely to hire employees with disabilities based upon the fact that, the research was trying to more recent research was examining why. A lot of this research was created after the ADA, so in the 1990s, and trying to follow the trend of whether the ADA and other anti-discrimination laws have improved employability for people with disabilities, and if not, why. So there generally, and I'm making a big generality here, based on my look at these studies, 3 factors that the research really examined for the poor rate of hiring for individuals with disabilities. The first was education and training, that many individuals with disabilities do not have the educational background or the training to compete with their peers that don't have disabilities. So that would be something like a high school diploma or a training credential. And so right off the bat, if you're going to set minimum standards for qualifications, it's going to impact the hireability of individuals with disabilities. The bright spot of these studies, in my assessment, is on that second factor, which is dependability. And what the studies really said is that individuals with disabilities rated better or equal to individuals without disabilities for dependability. So that means that employers were satisfied with the workforce that included people with disabilities once the employee was trained to perform the job. So the real barrier to employability in terms of the attitudes of hiring from the employer's perspective came down to, is the person qualified to perform the job, which comes to that third factor, which is vocational and supported employment. So under this factor, the employers were more likely to hire an employee that had completed a vocational training or engaged in supported employment. In fact, the 9 studies that I list here that since 1987 concluded that employers liked employees who engaged in these programs because they saw them as prepared in a way that applicants who had not completed these programs, even people without disabilities who had not completed the programs, were not prepared. So these are kind of important factors to consider when you're talking to people about supported employment, because I think it is daunting to see the number or the lack of hiring for people with disabilities. But I think people with disabilities have to know where they're, how to better market themselves to an employer, and to know what an employer's attitudes are towards people with disabilities, so that they can better prepare themselves for kind of the workforce. And this is one of those areas that I think this group, particularly when you're talking about vocational and supported employment and that kind of transition to competitive employment, why do I engage in those type of programs versus why don't I just go and get a job and see how it goes? This can be one of these examples of, you know, of what an employer might be looking for when they look at vocational and supported employment programs. So as I said, I was going to get into the rights of an employee with a disability, and I'm going to focus on today the ADA as well as the New York Human Rights Law. For those, I don't know if anybody is in the New York City area, there is New York City specific anti-discrimination laws in employment for people with disabilities, or including people with disabilities. A variety of populations are protected by it. I'm not going to talk about it today, but if you have any questions about it, I do have, DRNY does have a fact sheet or a, you know, kind of a 1 or 2 pager about that law. If you're interested in it, just pop a question into the chat feature, and I'm happy to give you kind of the link to that if you're in the New York City area, because the New York City area even has greater protections than these federal laws do. There are also other areas and localities that do have kind of local rules that may offer greater protections, and so it's important to kind of look into those as well. So let's talk about the ADA. Those that participated in the training I did a couple weeks ago, I used the same slide, so it should seem familiar to you, but I just want to make sure we're all on the same page, on the same page before I get into the specific area of the ADA we're talking about. So the ADA is an anti-discrimination law. It was, as I said earlier, passed in 1990, and it mandated that no qualified individual with a disability shall, by reason of that disability, be excluded from participating in or be denied the benefits of services, programs, and activities of a public entity, or be subjected to discrimination of an entity. So the ADA is an anti-discrimination law, and it has 3 titles. Last week I talked about Title II, which is the public entity. This week I'm going to be talking about Title I, which is specifically for employment. And Title I states that an employer is, Title I states that an employer, which is described as a covered entity, they can't just call them an employer, a covered entity cannot discriminate against a, quote, qualified applicant, which is a person who's either applying for the job, or a qualified employee, which is a person who obviously has the job by reason of their disability. So a covered entity, which is the employer, is defined as either a private employer of 15 or more employees, a state or local government, an employment agency, a labor union, or a joint labor and management committee. So in packaging that, the private employer that is responsible for not discriminating against people, qualified employees, or a qualified applicant, only applies to those private employers of 15 or more employees. But all state and local governments, all employment agencies, all labor unions, and all joint labor management committees, no matter how large they are also required, are a covered employee. So I hope that's clear. So now that we know who can't do the work, let's talk about who is covered under Title I of the ADA. Title I defines a qualified person with a disability as one that satisfies the requirements of the position and who can perform the essential functions of the job with or without a reasonable accommodation. This means to be eligible for an accommodation, a reasonable accommodation, the person has to have a disability and also be qualified for the position that he or she seeks to hold. So it's not just that the person has a disability, but that they are qualified for the job that they want to have an accommodation for. So I've been using the term reasonable accommodation. I think we all use it quite frequently, but I'm not sure we all fully understand what that means. A reasonable accommodation under the ADA is any change in the work environment or in the way a job is performed that allows the person to have equal employment opportunities. So that's pretty broad, but that means that to determine whether an accommodation is reasonable, there must be an analysis of the facts of the particular situation. So this is a person-by-person analysis, including not just whether this is kind of needed for the person, but the cost of that accommodation and the employer's ability to pay for it. So there's basically three kinds of, I've categorized it into three big kinds of reasonable accommodation. The first is a change in the job application process. So before you even get the job, the process that the employer is seeking the person to go through in order to get the job. This may mean that the employer needs to, let's say, accommodate an employee that can't handwrite an application or who needs to participate in a phone interview using a TTY line or some other means so that they can, in fact, even apply for the job. Again, in order to be a qualified applicant, you would have to also be capable of performing the job. So you can't just apply for something that you actually can't be capable of doing. But you, in applying for the job, the method established needs to also reasonably accommodate the potential employee. The second big category is changes to the work environment or the way the job is usually done, meaning that an employer may need to allow an employee to work from, let's say, a quieter location, as an example, than one that's set. So if the office space is a cubicle and they're next to the busy phone line, maybe their cubicle needs to be moved further away based upon their ability. They could perform the job, but they can't perform it in a loud environment. And the third category I have here is changes that enable the employee with a disability to enjoy equal benefits and privileges of the employment. So, for example, employers often give training to their staff. So access to training in a different way that allows the employee to learn the job would be a benefit that is given to all employees or privilege of that employment, which is training, job training, and that the employer might have to change that way they deliver job training to allow the employee with the disability equal enjoyment of that training. So I talked a little bit about this, but I think it's really important to understand that the employer can't discriminate against people with disabilities in all areas of the employment process. So I talked a little bit about application, but there's also testing in their assignments and the way they evaluate an employee, the way they've trained, I just talked about, promotions, layoffs, compensation, their leaves and benefits. So they can have a different process for people with disabilities, but they also can't have a process that discriminates against people with disabilities, even if that's not the purpose of their process. So let's talk about when applying for a job and what an employer can do before, this is all before offering the job to the individual. So if in the, let's say, application process, in the interview, in any background or reference checks, an employer can ask that of the potential employee, can you do this job? Or they can ask, do you have all the skills you need to perform this job? So they can ask about the applicant's ability to do the job at hand and have the applicant respond to that. But what the employer cannot do is ask, do you have a disability? Do you have a medical problem? They cannot use their background or reference checks to determine whether the applicant has a disability, and they can't require that the applicant submit to a medical exam. What they can do is make a job offer, so offer the person the job, and do a post-offer medical exam. That means you have the job so long as you're able to meet this medical exam, as long as every other employee is also required to complete a medical exam upon a post-offer. So let's say, for example, the applicant is doing a job that requires them to lift 50 pounds. They're they're working in a storage site and it requires them to lift 50 pounds. The job can be offered to the applicant, and then they can conduct medical exams to make sure that the employer can, in fact, lift 50 pounds, and that's permitted as an employer. So requesting a reasonable accommodation. If, I should say an employee needs, the employee should do the following. One, they need to tell their employer that they have a disability. They need to tell the employer how the disability interferes with their ability to do the job, and they need to describe what accommodations they think they will need in order to do the job. Now, this does not have to use any language within the law of the ADA. I put here, use plain English, and I think, you know, you don't have to mention the word reasonable accommodation, you don't have to mention the phrase ADA. The request for reasonable accommodation does not have to even be in writing. However, I would strongly say that the request, you know, advise that the request be in writing so that you have so that the employee or the applicant has a record of it. But there's nothing in the ADA that prescribes a specific format of the request for an accommodation. Now, this is what the employer needs to do once they receive a request for an accommodation. The first thing, and I think employees need to be aware of this, is they have to verify that the employee or the applicant has a disability. That means they're entitled to learn about whether the person has a disability and to review the evidence that the person has submitted, whether it's a doctor's note or have access to the individual's doctor to examine whether the person has a disability. They have to then identify the essential job functions that require an accommodation and identify a variety of accommodations to reduce or remove the barriers to increase productivity. Once they've done that, they should determine the cost effectiveness of each accommodation, which is an element of what their responsibility is under the ADA. And they're required to implement the most appropriate accommodation with the least economic hardship. So one thing I'll say, and this often creates kind of barriers for employees, is that there's no specific time that the employer has to respond to an accommodation request, but best practice would say they should respond quickly as possible. An employer should also discuss the request because the ADA talks about this interactive process and questions whether an employer has engaged in an interactive process in order to best meet the needs of the employer as well as the employee. That means that the employee is not entitled to the specific accommodation requested in the request. The employer may offer a different accommodation, and that's the interactive process that needs to go back and forth. The law, again, uses these general terms like unnecessary delays in responding or accommodating an individual violates the ADA. But again, the decision about whether something is unnecessary or that it's a delay is really a fact-specific examination for each individual in each request. So when does an accommodation become not reasonable? It's not reasonable if it requires the elimination of an essential job function. That's why it's really important that that employer and the employee really understands what are the essential functions of the job. Oftentimes you're looking at the job description to figure out if it's an essential function of the job, but the employer does not need to accommodate away an essential function of the job. It's also not reasonable if it results in lower production standards. So if there is an impact on the output of the employer, they may not need to provide the accommodation. If it involves the provision of a personal use item, such as a hearing aid or a wheelchair, so the employer does not need to provide these. The employer might have to provide access to the employee using their own hearing aid or wheelchair, but they don't have to provide a personal item to the employee so the employee can get the job done. The same thing, it wouldn't be reasonable if it results in undue hardship on the employer. So I'm going to unpackage undue hardship. An employer never has to provide a reasonable accommodation that causes this undue hardship, meaning significant difficulty or expense. It doesn't just refer to the financial difficulty. So you have these large companies like your Walmarts or your Targets, whatever. You know, it's going to be hard for them to justify kind of the financial difficulties in a billion-dollar corporation, but they still can be considered undue hardship. The reasonable accommodation is unduly expensive or disruptive or would fundamentally alter the nature and operation of the business. So undue hardship doesn't just mean that it costs the company money, although it may. It also can be about changing the way the company does the nature or operation of the businesses. So for example, some people seek to be able to work from home. It may not cost the employer any money to allow the employee to work from home, but if the employee's job is to, I don't know, put products on the shelf, it alters the fundamental nature of the job that the person's doing. Or if the job is to interact with people at the business location or interact with other staff, and it would create a disruption for the person not to be there, then it might be an undue hardship. Examples of reasonable accommodations, again, these are all going to be fact-specific, and there are some great resources for employees out there that can talk about different types of accommodations based upon the person's disability. But I just listed a few here. You know, making the existing facility accessible. So if you are using the wheelchair and you are bringing the wheelchair to work with you, you need to be able to access the work environment in your wheelchair. That would be something that is generally perceived to be a reasonable accommodation. Modifying the work schedule sometimes is considered a reasonable accommodation depending on the type of job. Reassignment to a vacant position, particularly if the person's eligible for a vacant position, that could be a reasonable accommodation to an existing job. Acquiring equipment or devices, adjusting or modifying the training materials, which we talked about earlier, and providing qualified readers or interpreters. It could be a reasonable accommodation so long as it is not considered to be an undue hardship. So an employee who feels that they are discriminated against by an employer in violation of Title I of the ADA has the ability to file a complaint. And I put the bottom of the slide is really important because the whole process of filing a complaint requires an employee to kind of pick and choose their path. And there are several different paths the employee can take. Generally, just if the claim is only for an ADA claim, the complaint needs to be filed with the Equal Employment Opportunity Commission within 300 days of the discrimination. And the employee must file the complaint with the EEOC before they can file a lawsuit. Generally, what happens is the EEOC issues what's called a right to sue letter, and it tells the employee that they can go and they can file a lawsuit in a court setting. The other law that I want to talk to you about briefly, and it's going to be very brief because a lot of it mirrors the federal law, is the New York Human Rights Law. This is a state law instead of a federal law, and the Division of Human Rights is responsible for ensuring an equal opportunity employment. They have a couple other areas, housing, public accommodation, education, and credit, which are very similarly mirrored to the ADA, but it was thought that this law might have broader protections before the ADA was recently amended to kind of clarify that more people with disabilities should qualify under the ADA than were being qualified under court decisions, which had been limiting who could qualify for protections under the ADA. So these are two different routes. One is a state law right, and then the other is a federal law right. And what the state law says is that it's unlawful for an employer, because of a person's disability, to refuse to hire them, to fire them, discharge them from employment, not pay them a fair wage, or use unlawful application process. The human rights law applies to employers with 4 or more employees. So as I said earlier, the ADA applies to employers, private employers of 15 or more employees. Well, the human rights law is broader. It's 4 or more employees. So there may be individuals who qualify for the protections under the New York Human Rights Law but do not qualify for protections under the ADA. So that's why I point this out to you. The qualifications are actually very similar to the ADA qualifications of what defines a person as a disability. And I list them here, kind of physical, mental, medical, which prevents the exercise of normal bodily function and demonstratable by medically acceptable clinical or laboratory techniques. So it's a diagnosis, in essence, of a physical, mental, or medical impairment, or having a record of such impairment, or being regarded as having such an impairment. And that's very similar to the definition of the ADA. An employer is not discriminating against a person with a disability by not hiring them or discharging them if, without reasonable accommodation, the person cannot do the job. And that's really similar to the standard that I just said for the ADA. You really have to be able to do the job in order to be protected by this anti-discrimination law. The process of complaining is slightly different than the ADA process. You have 2 options. You can file an administratively, which means you file with the agency, the Division of Human Rights, or you can file a lawsuit in court. You can't do both. If you select filing an administrative complaint, you will not be able to file a lawsuit. So what I can say is that the fact sheet that I have here, this web link, it applies to both the ADA and the human rights law, and it talks about the interplay between the 2. So before a person wants to file a complaint, I would suggest reviewing that or reaching out to our organization so we can review it with them. So speaking of Disability Rights New York, I told you I would tell you a little bit of background about Disability Rights New York before I did want to leave some time for you guys to ask some questions about this process and how it might interplay with what you guys do. So Disability Rights New York is, as I said earlier, the statewide protection and advocacy system and client assistance program. And I put our mission here, which is really to allow individuals to exercise their own life choices, participate in their community, and enforce their civil and legal rights. Our history is the same history as the whole federal protection advocacy system. It was created by Congress after the expose of Willowbrook. That's Willowbrook right there in that picture. It's kind of grainy on your screen, but that's an old picture of Willowbrook, which was a state of New York institution. As I said in the presentation, I think about a week and a half ago, if you have not watched the original news coverage of the video and you work within this system, I would strongly suggest that you watch it again. It's very important for us to understand our history, to understand where we are right now and where we need to be in the future. And I do think that it's something that we, at least when we go and do our outreach, we make you sit through at least 3 to 5 minutes of that video. And I think it's important for really understanding the core function of what disability rights and the protection advocacy system does. So the original purpose of the protection advocacy system was to protect the rights of people with developmental disabilities living in institutions from abuse and neglect. And it really mirrored why, because Willowbrook happened and they didn't want it to happen again. But now the P&A system, as individuals with disabilities find themselves less and less in institutional settings and more in community-based settings or in other types of settings, the mandate of the P&A is really expanded. It's been expanded to all people with disabilities on a broad range of issues in all settings where people with disabilities are, including private employment settings as well. The P&A system, which I think most people when I go around and do this training have very little knowledge of in New York State, is a national system there are 57 total protection and advocacy agencies in every state. There's only one designee per state and territory. So there's 57 of them, 50 states and 7 territories. Mostly they are not-for-profits, so private nonprofit agencies that are designated. But there are, I have 7 here. There's soon to be, I think, only 5 state agencies that are P&As left. And I'm going to tell you about New York State because up until 3 years ago, New York State was a state agency-based P&A. It is the largest provider of legally based advocacy for individuals with disabilities in the country, and it's also the largest provider of cross-disability. The P&A programs and the CAP programs, I've listed them here, and I've bolded, the ones that are really relevant to the employment discussion today and the population that you're likely to serve. But the first one was the program that was created out of the Willowbrook scandal, which is for individuals with developmental disabilities, called the Protection and Advocacy for Individuals with Developmental Disability, or the short acronym is PAD. Shortly thereafter, the program for people with mental illness was created, called the PAMI program, primarily for the same reason the PAD program was created, because state psychiatric centers are having just about the same problems as our state institutional settings for people with intellectual and developmental disabilities are having. And then less than 5 years later, we have the Individual Rights Program, which is called the PAIR program, which does also a lot of employment issues. And that program is to cover anybody that didn't qualify for the PAD or the PAMI program. Primarily working with individuals with whether aging issues or individuals with disabilities who have mobility or sensory issues that wouldn't qualify them under the PAD or PAMI program. Then starting in about 2000, there are newer P&A programs that were created and created kind of in all different formats. So instead of adding to the funds of the PAIR, PAMI, and PAD program, it appears to be easier in Congress to get a separate standalone bill for the protection advocacy system, and I think that's true probably of most programs. I think somebody's name goes on it and people get to sponsor it. So this became the newest fad for the protection advocacy system, is to create these kind of separate programs. So the next one, the individuals with traumatic brain injuries, was created. The voting access program, PAVA, was created. The assistive technology program was created. And also, the beneficiaries of Social Security was created. And I want to talk just a few seconds about that program. That was created out of the Ticket to Work legislation. It was really trying to assist people with disabilities with getting back to work. The purpose of that program is to assist anybody receiving Social Security benefits with any barriers to employment. And that's a lot of the work. Most of the work that is done in the PADS program is to deal with access to employment, employment discrimination, or any other barriers, whether they're housing barriers or benefits barriers that prevent people from working. And Disability Rights has been operating that, and I think it's a very underused program that we have here, and it does some great work, including wage discrimination work, including discrimination in the employment setting work, to assist people with making sure that they can receive a competitive, fair wage. The final program, which actually predates the P&A system, is the Client Assistance Program, and that is the program that assists people with access to the state's vocation VR program, vocation rehabilitation program. So that's either going to be the Commission for the Blind, or that's going to be Access VR. And any kind of concerns or denials or any barriers to working with the VR agency is what the Client Assistance Program does. And again, Disability Rights has been operating that for the last 3 years. In addition to the ability to provide direct representation to people with disabilities, the P&A system also has this broad access to monitor and investigate abuse and neglect, which is broadly defined. You know, the lack of providing services to people might be categorized as neglect, and it includes visiting service providers, interviewing people who receive services in there, interviewing people who provide the service, the service provider staff, reviewing individual records, and reviewing records of investigations by other agencies. How this interplays with some of you is if You may have run into a DRNY staff doing monitoring of sheltered workshop settings or other settings like that, interviewing individuals who receive services in those settings as a part of our monitoring and investigation authority. And both the PAB, the Client Assistance Program, the CAP, and the PAB program have really been doing this for the last year and a half. This is just general for your information. You know, the DRNY under the P&A program provides, and this is true of the Client Assistance Program as well, provides a wide variety of services to individuals with disabilities, including, you know, as simple as like information or referral to the individual to direct legal representation in legal proceedings or in administrative proceedings. We have the ability to sit down with policymakers and discuss the policies that impact people with disabilities. And we do this all under goals and priorities that are set on a yearly and sometimes triennial basis for some of our programs. So now I'm going to tell you the history of New York and the P&A system, and I'm hoping it's a little more familiar to you guys what the P&A system was like in New York, and that maybe you didn't know the P&A system and the CAP system, but you probably knew some of these other entities, and this is going to tell you how it's changed. So from 1978 to 2013, the designee of the Protection Advocacy System in New York State was the Commission on Quality of Care and Advocacy for People with Disabilities, which is a state agency. What that state agency did, CQC, is they contracted with other not-for-profit organizations to represent people with disabilities, basically to do the legal arm of the Protection Advocacy System. Somewhere around 2011, the federal funder of the program did an audit of New York system and had some concerns about this model of a state agency being the Protection Advocacy System and contracting with not-for-profit offices only to do the legal arm of the work. Some of the primary concerns was that an essential function of the P&A system is that it has to be independent of a service deliverer. It can't be connected to a service deliverer at all, which makes sense because one of the functions of it is to investigate a service deliverer like the state or like an agency that provides services, so it really can't be connected with that. And the audit really found that under the executive control of the governor, that a state agency wasn't independent, at least in New York State, of the deliverer of service, which also could be the state agency. So it asked New York to come up with a corrective action of how it was going to make the P&A independent of a service provider, in this case New York State. And what the governor of New York decided to do was to designate the entirety of the system to one not-for-profit agency. Instead of existing contractors, it would go to one organization. So the incorporated name for Disability Rights New York is Disability Advocates, and Disability Advocates was one of the not-for-profit contracting offices for the 20-plus years that the Commission on Quality of Care was the designated protection advocacy system. And so Disability in 2013 became Disability Rights New York and became responsible for the entirety of the state of New York in delivering the P&A system. So the Disability Advocates, we carry out that function, as I said, with offices in Albany, Brooklyn, and Rochester. It's not the way in which the office works is it's not the Brooklyn office handles downstate, the Rochester upstate, and Albany handles the central portion of the state. In fact, we operate as one organization, and we have teams across all the offices that are responsible for the different programs, and each staff person is responsible for a statewide function. They operate across New York State. They don't have a geographical barrier to where they operate. And how Disability Rights New York functions this way is we have a centralized, what's called intake process, which anybody who calls us for assistance, whether you're calling on behalf of a person with a disability or you're calling as a person with a disability, an intake is conducted. It takes about 10 to 15 minutes just to get some specific information that generally is needed for our federal funders. And then it's assigned to the different programs, and an attorney reviews it to determine whether it falls within Disability Rights New York's priorities, and if it does, the case is assigned to an attorney or advocate within the office or one of these offices. And whether you call, when you call the centralized number, we have an integrated phone system, and you're immediately patched into whatever office where the staff person you're working with works with, so you don't have to try to find them in whatever office they work with. And so there was really a concerted effort to make sure that we cover the entirety of the state, and that may mean that a person that works in Brooklyn needs to, when resources require it, do something in Rochester or Plattsburgh or wherever, Binghamton, and that they're available to kind of do that as the organization structure is set up. I talked to you about priorities for the program. Both several of the P&A programs, whether it's PAD or PAMI or PABS or PAIR, and the Client Assistance Program really have a specific priority to assist people with disabilities to access employment, to be free from discrimination in employment, and be paid at least minimum wage. And that's really a focus across DRNY, is to work on employability issues of people with disabilities. So whether you're calling for technical assistance or questions about employment, or you know somebody who's having a barrier to employment, I would just strongly encourage you to reach out to organizations so we could see whether we can help them with those problems. This is our contact information, and like I said, the first line of telephones, that's our general number. No matter whether you're calling in Brooklyn or Rochester or whatever, that's the number you're going to come through our central intake. Feel free to use the 1-800 number if you're outside of the 518 area code. Also, we do take intake via the email if people prefer to write things down via email. And I encourage you to go on our website. There's lots of information on our website, including those links that I sent you about employment guides. Under our publications and reports, if you scroll down, we have something like 35 fact sheets that are in all different areas that are really trying to target the audience is the individual with a disability, is trying to target and give specific answers about specific questions. And if that doesn't resolve itself, we're happy to have you call us, and we can walk through on an individual basis any questions or concerns the person might have. So I thought maybe we could open it up. I wanted to give some time. I think we got a good amount of time for some questions and a dialogue about concerns related to this topic.
So if anyone has any questions, you can type them in, or you can raise your hand and Nicole will unmute you. So while we wait for people to raise their hands, I had a question, Jennifer. So if somebody is working, in an integrated employment setting and they feel that they're not obtaining the reasonable accommodations they think they need, they would be able to call disability rights. Is that correct?
Yes, absolutely. I mean, and some of the things that we might, so I want to make something clear too. It's not always the best route to immediately have an attorney jump in and call the employer, because there is a risk of, retaliation or changing the dynamic. So some of the things that we do, and I think it doesn't mean that we don't actively get involved in these things. Some of the things we do is really try to educate the employee and work with the employee to make a request and to make sure it's in the right format before jumping in as an attorney. We might not present ourselves, in other words, to the employer right away. We might use other resources. And the reason isn't because, we're overstaffed or we're too busy. It's because we've had success in empowering the individual to take the right course of action and get to the right person. And that has eliminated the risk of retaliation, which is also something that we get involved in if the employee is being retaliated for asking for accommodation or for advocating for their rights. But it's a process, and we generally recommend not having an attorney kind of storm in until the groundwork can be laid for the claim, because sometimes the employer, all of a sudden it gets to the right person and they recognize what they're doing and they stop doing it, and therefore it creates less of an upheaval in the job for the employee. So I just want to be clear there. Yes, we actively involve. Yes, the person contacts us, but you may not see our presence right away because we've advised the employee that we want to stay in the background until we can see if a few things resolve the problem.
So kind of like plain devil's advocate, if somebody were to come to disability rights and feel that they were being discriminated against, but in reality they were encountering a reasonable expectation for someone who is employed in a regular job, what would your approach be to that? Do you work with like the employment specialists or the job coaches, or how would you kind of help the person to understand that, you know, there are certain responsibilities associated with employment?
Yeah, we try to, again, we engage, when the individual calls us, what happens is we have an attorney-client relationship, okay? So we can't talk to anybody else or share what we talk about with that person with anybody else without their consent. But we often do try to get consent to speak to their, you know, their support team, whether that's an employment specialist or their service coordinator or something like that. But the first thing we generally do is educate the employee on a one-to-one conversation about whether we think that the thing being asked is reasonable. And if we do, we tell them. We may not have the ability to tell other people that we've told them, but we do educate them about what their responsibilities are in an employment setting. And sometimes it coming helps. Sometimes the employee is not receptive to it, but oftentimes we really lay out whether it's a reasonable expectation what the employer is saying. And then if we do get consent from the employee to talk to their support team, we will share with them what we've said, and we will also give some kind of concrete steps for the employee to take to address their concerns. But if it's, I don't really want to go to work every morning at 9 o'clock in the morning, you know, oftentimes the conversation that we have is, well, that's the job you have, and the reason why you want to have that job is because without that job, this is what's going to happen, and with this job, this is what's going to happen. So we try to give them concrete examples of how employment can be, is different than leisure time, but in order to fully enjoy your leisure time, oftentimes employment is an essential key factor, and we try to examine with the employee why employment is important.